isn't scheduled until noon. It is Mildred Stiles versus Marc, Glassman, Inc. Are both sides here to argue that? And are you ready to proceed, or would you? Okay. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning and can keep you apprised of the passage of time. Court has read the briefs, and we are ready to proceed with the argument.
Good morning, Your Honors. Jessica Bacon on behalf of the appellant Mildred Stiles. I would like to reserve 3 minutes for rebuttal, please. Thank you. There are 2 assignments of error presented for your review today. The first is that the trial court erred in granting summary judgment on an issue that was not moved on by the defendant. The defendant, in this case Marc, moved for summary judgment based on the open and obvious doctrine. In support of that argument, Marc argued that the water that Ms. Stiles fell on was open and obvious because when her mother walked in from the car after being told that her daughter had fallen, she testified that she could see the water running down the aisle from underneath or near this watermelon crate. It was a cardboard watermelon crate on a wooden pallet.
How much time was there in terms of her coming in, and how much time did she have to look?
She, Mrs. Stiles' mother, estimated, based on when she was told that her daughter fell, that it was about 10 minutes or so that she had been in the car and then was told by another person to come back into the store. Thank you. It's important to note this argument that Marc's made in support of summary judgment because Marc's acknowledged what the alleged hazard was, that it was water on the floor under or near these watermelons. Plaintiff responded to the open and obvious argument by citing the summary judgment standard and by reminding the trial court that the 8th District case of Carpenter versus Marc had determined that if reasonable minds could differ with respect to whether a danger is open and obvious, then the obviousness of that risk or hazard is an issue for the jury to determine. Plaintiff also distinguished the defendant's case law as well as cited to her own case law, indicating that the testimony of the plaintiff at a minimum illustrated that an issue of fact existed as to whether or not the water she fell on was open and obvious. She testified that it was clear and that it was coming from underneath this watermelon crate and impossible for her to see it until she was lying in it. The trial court granted summary judgment in favor of Marc on grounds not moved on by Marc and supported its decision with distinguishable case law. The trial court aligned the facts of this case with 2 other cases, Andamasaurus versus Annunciation Greek Orthodox Church, decided by this court in 2005, and Tenney versus Tadaro's Party Center. The main factual difference between those cases and this case is that in both of those cases, neither plaintiff could articulate what caused their fall. They knew it was a liquid, but they had no idea where it could have come from or what exactly the liquid was. The Andamasaurus case, a woman fell at a wedding reception on the dance floor. Many witnesses had testified that it was very obvious that that floor was wet all night. It was right in front of the bar and people were spilling drinks while dancing. The other case, Tadaro's, is where a woman fell in the restroom, in a public restroom, which is often inexplicably wet. In the case of Mrs. Stiles, she did testify that she knew it was water that she had fallen on and where it was coming from underneath this crate. The case is clearly distinguishable from the case law the trial court relied upon for the reasons that Mrs. Stiles could articulate her fall. Specifically, in its ruling, the trial court noted, quote, "The court finds summary judgment is appropriate, considering that plaintiff is merely speculating as to the cause of her fall. And summary judgment is appropriate if a plaintiff cannot identify the reason for the fall. Well, that's not a ruling on the open and obvious doctrine. That's a ruling based on the case law that I just discussed. And despite the fact that that reasoning is flawed, as plaintiff did identify the cause of her fall, what's important for today is that was not an issue raised by the defendant. The source of the fall, the inability to articulate the reason for the fall, was never even mentioned or referenced by the defendant. The only argument was raised is the opposite argument, that the condition was open and obvious. A condition cannot be both open and obvious and completely unknown to the plaintiff that they can't even say what it was. If the argument is, it was so obvious they should have seen it or had an opportunity to see it. Plaintiff was not afforded an opportunity to respond to the argument that the reason for her fall could not be articulated. Plaintiff was not afforded the opportunity to distinguish the case law, which is clearly distinguishable, because the first and only time this argument was made is in the court's ruling. For those reasons, those are the reasons that support plaintiff's first assignment of error. The second assignment of error is a little bit unique. In its motion, defendant asserted that plaintiff's case should be disposed of because an expert report was not filed pursuant to the court's order. The court did put out a trial order, and in that trial order gave a deadline of May 1st for experts to be identified and reports to be filed, noting the opinions an expert would testify to. Plaintiff responded in her motion, or in her opposition, that the treating doctor from the Cleveland Clinic had been identified on numerous occasions, including in response to discovery. The doctor's medical records had been provided, and it was highlighted that in the first note following the date of injury, the doctor from the Cleveland Clinic included a history of the fall and a diagnosis of knee injury, unspecified knee injury, and knee pain. This record in itself gave causation. Plaintiff, it is correct, plaintiff did not file an expert report on the date that was indicated by the court. Plaintiff did not have the doctor create a report in which he would copy and paste that paragraph from his note onto letterhead and stamp expert report on it and charge a fee. It just wasn't, in plaintiff's mind, worth the expense of that because this wasn't a case that required expert testimony. We believed
It requires expert medical testimony as to cause and damages.
I don't believe that it does. And the reason for that is because this was not the kind of injury that would be beyond the common knowledge of jurors. This is a situation.
To the extent she's claiming over $38,000 in damages and the potential for a knee replacement, I would submit that this is other than what you just said.
And I can appreciate that. The amount of claimed medical damages, it's near $40,000, is based on the Cleveland Clinic's billing for several diagnostic testing. If you had the ability to see the records, you would see that every time Ms. Stiles went back to the doctor, she would say, my knee is still swollen, I'm still in pain, and they would do diagnostics, which has led to this billing. This is nowhere near $38,000 in medical treatment. And there was never any diagnosis beyond knee pain and contusion ever given, despite all these diagnostics. So this is a situation, and usually I'm arguing the other side, but this is a situation where the amount of medical bills is really not equal to the severity of the damages in this case. The main question and the main assignment of error that plaintiff is asking for you to review today is that the trial court's ruling on this issue seems to be that no case can ever be tried without an expert. The trial court's ruling, quote, says, quote, because an expert report has not been produced, plaintiff has failed to establish her injuries are a direct result of Marc's negligence. Well, any medical expert opinion rendered in a case like this is never going to say that the defendant's negligence was the cause of the injury. That's not the purpose of a medical doctor. The best a doctor can do is simply indicate the mechanism of injury that led to the diagnosis as opposed to some other cause or injury. In the medical records that were provided to defense counsel, the treating doctor did just that, noted that the fall caused the injury. The way the trial court ruled on this issue is very problematic, as it reads that no case can ever be tried without an expert, and that's just not accurate. There are cases tried without experts all the time. To grant summary judgment on this issue and dispose of the case on this issue is saying that there's no issue of fact on this issue, the issue being causation, as I take it to read. And this is absolutely incorrect. The medical records and Ms. Stiles' testimony indicate the injury was caused by the fall. To dispose of plaintiff's case at an early stage under the presumption that plaintiff would, one, have to have expert testimony in order to establish proximate cause, and two, that the medical records would not be admitted into trial and sufficient to establish that, is highly prejudicial to the plaintiffs. The question of whether a plaintiff can prove proximate cause is a question for the jury. And that is specifically noted in the same Anda Masaris case that the trial court relied on for the rest of their ruling. That court says, quote, "The question of whether a plaintiff can prove proximate cause is a question for the jury to decide. It is not an issue to be decided as a matter of law by the court." That's where the duty issue comes in. That's the matter of law to decide. Proximate cause is a fact for the jury and not an issue that should dispose of plaintiff's case. Thank you.
May it please the court, my name is Jim Henshaw, and I'm here on behalf of the appellee, Marc Glassman, Inc. We believe that the trial court correctly determined that there was no duty owed by Marc's to the plaintiff in this case. Our motion for summary judgment was based upon the open and obvious doctrine, and we argued that there was no duty based upon that doctrine. The court made its ruling based on the record before it, which was the testimony of the plaintiff and the plaintiff's mother. The plaintiff themselves did not present any affidavits or any other admissible evidence in opposition to that motion. The trial court reviewed the plaintiff's deposition transcript and the testimony and determined, as the appellee was arguing to the trial court, that no duty exists, but for a different reason, that it was not the duty that the trial court ruled upon, the no duty, was based upon the court's determination that there is no duty if not such an unreasonably hazardous condition existed. And that was the basis of the trial court's ruling. So although we were arguing no duty based on open and obvious, the trial court ruled no duty based upon their review of the plaintiff's testimony. And as everyone knows, whether a duty exists is a question of law for the court. And the trial court ruled that there were no triable issues in this case. So we believe that the court determined that there was no duty owed based upon the plaintiff's testimony, and we asked this court to affirm the trial court's granting of judgment as a matter of law on the liability issue, and based upon that, we believe the court will not even have to determine the obvious failure to provide the medical report issue, in that the ruling on the liability issue would, we believe, dispose of this case. So if there are any questions, I will be happy to take this.
I do have a question. With respect to the mother's testimony about her observations upon entering the store, does that have relative value to the finding that there's no duty because there's a finding there's no unreasonably hazardous condition?
I believe that the trial court, first of all, to answer your question, there is no question that the mother testified to that. However, the trial court, in reviewing the plaintiff's testimony, specifically the plaintiff's deposition, page 20, lines 19 through 21, in which she stated that the plaintiff stated she did not see any water in the area where she fell. And I believe that was very important in the trial court's determination, that there was no water in the area where the plaintiff fell, according to the plaintiff's own testimony.
That she testified that she didn't see any, or that there was none?
She said that she noticed or knew it was water after she fell down.
Because her pant leg was
Wet.
wet, correct.
All right.
But when I asked her if she saw any water in the area, she testified that she did not see any water in the area where she fell.
So from that, are you arguing that she was not looking carefully, or that under whatever circumstances there existed, no one could have seen the water?
I believe that the plaintiff's testimony was that she had an unobstructed view of the floor, and that if she had been looking where she was walking, she probably would have seen the water if it was there, if that answered your question.
Yes.
So,
She's, at the time of her fall, she's not alleged to be walking. She's alleged to be placing something inside of her car.
Lifting the watermelon.
I guess I'm not sure how to answer that. She was in the process of putting a watermelon into the cart. I believe her testimony was that the cart, when she fell, did not move at all, but I can't represent to the court that specific answer without looking at the transcript. If there are no other questions, we would respectfully request that the court affirm the trial court's determination of the granting of summary judgment in this case. Thank you.
Thank you. So a very brief rebuttal to address a couple of points. Your honors were correct, and I was going to point out that the testimony is not that Ms. Stiles was walking at this time and not looking where she was going. She was not walking, but stepping around a square crate of watermelons, cardboard box type of watermelons on top of a wooden crate. And when she stepped around it, that's when she fell. She was so close to the crate that that's how the injury was caused, because her knee struck the corner of the wooden pallet that it was on top of. And all I'd really like to highlight as far as this first assignment of error, which was really the only one addressed by opposing counsel, is that a plaintiff cannot, nor do I believe they're required to, anticipate every argument for summary judgment that could have been made but wasn't. When responding to the summary judgment, plaintiff responded to the open and obvious doctrine, distinguished the open and obvious case law that was put before her at the time. I believe that it was unfair and highly prejudicial of the trial court to not rule essentially on that issue of open and obvious, but to rule on completely different case law and a completely different circumstance that the reason for the fall could not be articulated.
But in the trial court's entry, it says, thus by her own admission, plaintiff's failure to observe the wet condition was due to her own inattentiveness. Is that not a ruling on the open and obvious?
Well, I don't believe it is, because I don't believe those facts are correct. I don't believe they were correctly interpreted by the trial court. I don't think that's an issue in open and obvious, because the open and obviousness of the condition was never addressed. That was more of a copy and paste, for lack of a better term, from the defendant's brief, and I did not have the opportunity to, I did address that in my motion, and if that had been the sole and only reason, I would be standing up here with a different set of arguments. It doesn't appear from a reading of the trial court's order that that was the reason while summary judgment was granted. Anything related to open and obvious, basically because the court, and I can quote it, said, the court finds summary judgment appropriate because she cannot articulate the reason for her fall. So I believe that is the reason why summary judgment was granted, and that was an inappropriate ruling based on the circumstances.
But if the court finds that she admits that her failure to observe the condition was due to inattentiveness, does the court need to then go on to objectively assess whether or not it was open and obvious, if you're addressing that issue?
I don't think the court needs to decide objectively if it's open and obvious, but I think that that's an argument that I should have had the opportunity to distinguish the case law that was used and put the facts in the context that they came in from the deposition, not the context they were put in defendant's brief and then copy and pasted into an order. I still think that the order is very clear that the finding is because she could not articulate the reason for her fall, as supported by the case law that the trial court cited in support of its ruling. That doesn't even relate to open and obviousness. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which we mail to both sides, as well as post it on our website and the Supreme Court website. Thank you. We are adjourned until next Tuesday.